Hello, good evening, and welcome to this episode of the Insights Express series, where we go deep and dive into different matters, different aspects, making news, or where we sit on a virtual platform to discuss issues that have not probably met their worth across different platforms and legacy media. So we come here and discuss further and create an insight and cast a spotlight where it has not been casted, or deeper. So tonight, I'm privileged to be hosting Senior Counsel and President of the Uganda Law Society, the Radical New Bar, Isaac Ssemakadde, Senior Counsel, who will be our guest tonight. Good evening.
Good evening, Arnold.
Okay, everybody on the space, now that my guest has joined the space, we can start the conversation, and we can have a conversation now. So everybody, good evening and welcome to the space. This is another episode of the Insights Express series featuring Senior Counsel, President of the Uganda Law Society and Head of the Radical New Bar, Counsel Isaac Ssemakadde. But tonight, we go deep. We want him to cast for us a spotlight onto the position of the law in the state of our affairs as a country. We are live on X, as you all know, broadcasting straight from the trenches of the Constitutional Court, where the rule of law is either missing in action or under active siege. Tonight, we strip away the elite diplomatic public relations. We break through the polite boardroom legalese, and we cross-examine the system with raw fact-based lethal precision. The dock is loaded, the state is on the stand, and our guest tonight, Counsel Isaac Ssemakadde, is ready to cast for us a spotlight into the matter. Like I said, it's a conversation, it's a conversation of the present, but it's a conversation from the future. And it's another episode of the Insights Express series with Counsel Isaac Ssemakadde. Senior Counsel, good evening and welcome to the space official.
Good evening, Mr. Katongole. I'm glad to be back for the May edition of the Legal Cast. I look forward to a sumptuous conversation with you and my colleagues, brothers and sisters listening in from Uganda and the diaspora.
Thank you very much, Senior Counsel. Last time, for those joining in for the first time, the Insight Express series, last month we had the Judiciary Unplugged, where Counsel Ssemakadde took us through different facets, unplugging the judiciary and the different issues that we are facing, and the different crises, and he's proposed so many remedies. For those of you that didn't attend that space, Counsel Ssemakadde honored our invitation as the Insights Express series and was here. And this month, several of our listeners and everybody asked that we return Counsel Ssemakadde, because from where we sit, the position of the law is one to scrutinize, but we need the best of minds to scrutinize it. And we had a suggestion to return to Counsel Isaac Ssemakadde. Thankfully, he honored the invitation and is here tonight. So several incidents, Counsel, this is where several incidents that are happening. This will be our rundown of the issues that we want to look at. The subject focuses legislative opaque budgeting, civil society deplatforming, digital dissident, containment, and electromilitarization. These are some of the things we are going to look at, but the conversation is not limited to only those, but they lead the agenda tonight. And my first question to you, Counsel, on this episode, last time you told, anyway, let me begin it from here. Counsel, on this very episode, where does the law stand amidst our current affairs today? Let's first talk about that.
For those joining us, they may be shocked to hear when I say that the law is absent in our current state of affairs. The law is as strong as its protectors. And in Uganda, the major institutions are the judiciary and the Uganda Law Society, the practicing lawyers, as well as the citizens. Now, the sum total of what we discussed last time was that the judiciary exists in name only. It is littered with a few good judges, but the pillars of the institution, the pillars of judicial culture, have been smashed. We discussed at length the office of the Chief Justice, which as I speak is vacant. It is filled by a nominal placeholder who occupies it, as we discussed, extra constitutionally. For most Ugandans, I think their expression of disgust was the whole swearing in ceremony and how it didn't reflect any of the elements of statehood as compared to what you saw with the swearing in ceremony for the parliament. It had the solemnity of statehood. Here where, well, Kororo is now constitutional property for you, but it was a place, it was a site, designated site of parliament. It was the seat of parliament. So the head of the parliamentary institution and his deputy were sworn in on parliamentary estate. Why wasn't the Chief Justice sworn in on the court estate, judiciary estate, or in keeping with tradition, a state house? So anyway, but the Chief Justice was appointed by the President following a recommendation by Judicial Service Commission that is improperly composed because it lacks the two representatives of the Uganda Law Society. The Judicial Service Commission is the subject of ongoing litigation, including constitutional petition number 11 of 2025, constitutional application number 12 of 2025, challenging its current composition, challenging the law under which it's operating, the Judicial Service Act and the Judicial Service Regulations of 2025. Now those matters were before the Constitutional Court, which was then led, which until January this year was led by the current Chief Justice. So the as Deputy Chief Justice, head of the Constitutional Court, he was supposed to fix those matters for hearing. The important question whether or not the Judicial Service Commission should continue to operate, to conduct the business of recruiting judges in light of these constitutional questions. But he sat on those files. He failed to do a constitutional duty. And then he got a benefit from that unlawful act, which is classical definition of conflict of interest. So we have a lawbreaker having benefited from the actual breaking of the law. He then submitted his name for the race of Chief Justice before I challenged the constitutional body. And apparently, it sent his name to the president as the winner of that race. And the president quickly put him in that office. Now, that is the head, and he's not the only one. We now have the Deputy Chief Justice elected through the same process. We have the Principal Judge. We have the Chief Registrar. All of them, they have come through this constitutionally delinquent process. And those are the heads of the institution. We have had sufficient time to see his first act. We saw the Gava court proceedings. I think that was before our first space. Maybe we shall discuss them in detail. But they showed us exactly whether the judiciary is independent. And I think the Uganda State moved to court to challenge the absence of law, the absence of the observance of law in a matter which was in public view. And the judiciary denied us a hearing actively, obstructed justice. So, for a non-keen observer of the law and Ugandan events, they may be shocked to hear a conclusion that the law is absent. But with these events which you can better articulate in vernacular or in simpler terms, my duty is to provide a summary of it.
Wow.
The first test. That was the first test for the Chief Justice and the Principal Judge. They failed the test. So again, lastly, I think on this point, a definition of the rule of law maybe begs repetition. We defined it last time as the ability or willingness of judges to declare state action unlawful, to declare actions of the powerful, the rich, unlawful. You see, the powerful and the rich don't actually need the law. Power in itself gives them legroom to do what they want. So it is us, the powerless, who need to approach judges and seek protection of the law. To the powerful, to the rich, the law is in their hands. The law is a weapon. They use it to advantage themselves, to protect themselves, to maintain their privileges. We, on our hands, are promised that we can appear before a judge and seek a declaration of unlawfulness of their conduct. Is there willingness and ability? I don't think so. When you check the mode within the practitioners of law and their clients, there's a very low perception of the ability and willingness of judges to make such declarations. There's a higher propensity for judges to seek to protect themselves against the rich and powerful by declaring their actions lawful or by refusing or delaying to provide declarations of unlawfulness. This is what the ordinary Ugandans see in their ordinary courts, which are the magistrates' courts, for instance, in cases where power, questions of power, contestations of power in all its forms constitute the state of affairs. So at every interaction with power, if we bring that within the institutions of law, there is more likely failure. I think the last event that I can cite in support of my submission that the law is absent in the current state of affairs is the speech of the retiring judge, Justice Egon Dantende. Are you familiar with it, Arnold?
I
Hello?
saw that. Yes, I hear you, counsel. I saw that Justice Egonda
Yes.
Ntende resigned or retired, but then
He
I'm not
retired.
familiar with.
He's
Yes,
retiring. He'll be retiring, I think.
yes,
So the judiciary held a farewell party for him. They now call it a special sitting. You can go like it and speeches made by his colleagues in his career, which spanned yes, um
is someone hearing Counsel Semakadde?
from 1991 now. So
Counsel
he,
Semakadde,
he also
yes, now I hear you.
left meeting. But he's I
Yes, I hear you now.
hello?
Yes, I hear you loud and clear.
So where did you stop?
I stopped at the point where
Yeah,
you were talking about the speeches between him and his colleagues, about his colleagues speaking about him.
oh yes. So yes. So deliver the speech, of course, is the main. As the Mugole, he also Aba Mugole, as the person in whose
Yes,
honor
main celebrant.
the events. Yes, he 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 delivered this. I think in English it's called a valedictory speech, and he made the following. He touched many things, but I think a part of which went viral. There's a statement that Team Judiciary, where are your Wambuzis today? Where are your chitios? Did you hear those words moving?
Yes, I did.
Yes. And he also cited one anecdote to show that the law is absent in the Cabinet of Affairs. And I think he cited a case which many Ugandans understood to mean the mistreatment of one political prisoner to represent many thousands of political prisoners. That is Alex Mufumbiro. Because his situation, I think, received outsized attention when he lost his wife recently, and his children were seen burying their caregiver, but at the same time having to contend with an absent caregiver who would otherwise be present. In the words of the judge, he's locked up in a prison on the most flimsiest of charges which are bailable, and the reasons for not giving him bail are not known. They don't make sense to any Ugandan. And this is a judge, a highly reputable judge living. So this is the kind of situation. And therefore, the law exists only in scraps and portions of resistance. We are fighting lawlessness. and we must use in a desert, you call them oasis. So the little law you get to see, the little law we get to practice is in an oasis. And sometimes it turns out to be a mirage. But otherwise we can typically call Uganda in jurisprudential terms a Sahara desert. Yeah.
Wow, what an opening statement there. Counsel Isaac Semakadde telling us, verifying or now giving us a result of where the law stands in the current state of our affairs as a country. And with that statement, there are questions and points I was picking out and saying, if, for example, people on the other divide or people in government would say, but we have appointed a chief justice. We have appointed the people in judiciary. We have given judiciary money. We have put up agencies that help the judiciary function. They would say we have a parliament that has passed several bills, is passing laws, and we are not entrenching on their mandate. That's what people on the other side would say. They would say we have hired more judges, we have increased the pension of judges to enable the judiciary function and work well. But from the light that you cast here, counsel, is that it is a system, because when you caught the Thanksgiving party of Justice Ngonda here, you talk of people like Justice Wambuzi, who just made 95 years, I think, of late. I saw his birthday. And you talk of, last time you talked of the different justices, the Justice Sekokols, the Justice Kanyehambas of this world. And you also said that the last Chief Justice we had as a country was Chief Justice Emeritus Pat Katrebe. But one would argue that we've had two Chief Justices since then, but now you've said a criminal is operating and occupying the office of the Chief Justice. But that, in a summary, you've tried to show that the present day time events that we are seeing and the lack of charismatic or those core judges that you would look at.
Patriotic.
Yes.
Patriotic
Judges in the real sense of patriotism, or in the sense of what we should understand as patriotism. Someone now would say that Isaac Semakadde, you're not patriotic to this nation after that submission. But how did we get here? How did we slowly lose the core hand, or the core patriots, like you've referred to them, to where we are?
Thank you. Let me first of all deal with what you called the rebuttal, the counter accusation by the other side. I will deal with it simply by using a tale of two cases. Are you hearing me?
I hear you loud and clear.
In January, we had an election on 15th of January, right? And there was an election petition filed by one Kasivante Robert. Do I get the name right?
You get the name right. Kasivante took a petition to the Supreme Court and then withdrew it.
Yeah, but before he did withdraw it, that means that the existence of that petition created a simmering constitutional crisis which had to be resolved quickly by ensuring that the proper organs of the constitution attend to it dutifully, right? So very quickly we saw, last time we discussed that the Chief Justice, the predecessor to the current lawbreaker, hurt us as a republic by overstaying until January 18th, his last day of retirement. Meaning that by the time we came into an election petition, a lame duck Chief Justice was occupying office, knowing that actually 3 days after the election, he's just going to retire. Why did he leave 6 months before? So that we have a functional office. So this man stayed until 18th, and then the judiciary and the government scrambled to appoint a Chief Justice quickly. I think they were able to do these rapid processes by 23rd or thereabouts. You get me?
Yes, I do. Yes, I.
That's why we saw that hashed up and rushed swearing in ceremony at a farm in somewhere in a bush. Now and then, so that this petition, because there are timelines for hearing that constitutional petition, that election petition, can receive attention of a fully constituted Supreme Court, because under the law, the Supreme Court is constituted by the Chief Justice and other judges. So if there is no Chief Justice, there is no Supreme Court. Are you hearing me, sir?
Yes, I'm hearing you, counsel.
Yeah, so the government was able to quickly fill this position and create a sitting so as to unburden the executive branch of questions about legality and legitimacy in its transition. Are you getting me?
Yes, I get you clearly.
Was similar speed and devotion brought to the filling of vacancies in the Judicial Service Commission
No,
and the judiciary?
not at all.
So what is responsible for the disparate treatment? That's my answer. That would be my answer to any one of those people who says that, the government makes available all the necessary resources to these other institutions to do their job and doesn't interfere. That's not true. Is it very clear?
Yes.
So what we have now is, and that brings me to the second thing. What we have now is a fusion of the judicial branch with the executive branch, with the ruling party, and with the emerging dynasty of the Museveni family, what in the literature they call Pax Musevenica, and its military appendage. So that is the situation we have. That constitutes replaced rule of law. How did we arrive here? The answer, quite simply, is that it goes to the formation of the Republic of Uganda and the point at which anyone wants to engage with it. Now, for some people, they engage with it only as far as the events of last week, last month, or last election. Those who are more serious skip even the last 40 years and have an appreciation of the impact of 1980 and so forth until 1900. And even before 1900, we can look at the arrival of, the first colonists and the legacy of colonialism. So I am very impressed.
Counsel, you've mute.
Sorry, my son asking for something.
Oh,
I'm turning to my son.
it's okay.
What do you want?
So guys, we continue the space once again.
So,
Okay, you back?
so I was saying that I'm very impressed. I'm very impressed that some Ugandans who are not lawyers have a very good appreciation of how we've arrived here. I came across a conversation, I think, by a one General Bigirwa. Yeah, is it called Bigirwa?
Yes.
General. And he could narrate the Ugandan problem along the critical junctures for constitutional law, from the raising of the Union Jack in 1894, perhaps even, I think, the invitation of the first missionaries in Uganda in 1888 by Sekaba Kamtesa. But he tells this story, comes down to 1900, understands the 1902 order in council, understands the 1920 orders in council. He has a good recollection and the implication of the Bataka uprising and agitations between 1920 and 1949, the formation of political parties starting 1950, comes to the first set of governance in 1961, independence in 1962, the crisis of 1966, the constitution of 1967, understands the coup, the Amin coup in 1971, and all the major political junctures that we are taught in constitutional history in year one, explains, and by the vernacular, the fall of Amin, 1979, April, and the various attempts at reconstituting democratic governance between 1979 and 1980, the three governments we have during that time, or four, according to some, understands the contribution of the second Obote, regime from 1980 until 1985, the fall of that regime in 1985, the fall of the Tito regime, Tito Okello regime in 1986, the arrival of Museveni and the NRA in 1986, and what they did with the first 10 years between 1986 and 1996, the 1995 constitution, up to now, let me just skip. So, because we are a largely young nation, and also because our conversations are sort of rushed oftentimes when we have them, we tend to sort of truncate this story. So I have been accused, and I accept the accusation, of being a romanticist with the 1995 Constitution. The short version of the story of how did we arrive here is that we can take it that Uganda was led chaotically, and an elite bargain it was arrived at in 1995 and settled in the 1995 Constitution. That those who were alive and active in politics between 1986 and 1996 engaged in a fairly representative national dialogue. You hear me, Mr. Arnold Katongole?
Yes, counsel, I hear you loud and clear.
Yeah. So if we can forget the past, and we are always invited to forget it, to just leave the legacy of colonialism, the legacy of Armenism, the legacy of everything, and just start at the renewal. So so I think for you call it what, the sixth parliament. So that we just start with this. What went wrong? Why is it that the promise of the entire constitution hasn't been arrived at? Well, that would be the short version. It is easy to look for scapegoats in providing a short answer to that question, but on my part, I think when I was elected president of the society, and even before, I think I gave shortly before I gave a keynote speech at Victoria University on the 26th or 27th of September 2024, answering this very question. And I told that community, because it was students and their lecturers, that we're not the only, we're not unique in attempting a constitutional republic. There are many countries that engaged in this process post the Cold War in Africa and in Europe. There are many emerging nations. Even our neighbors here in Sudan are a very young republic, and they are attempting a constitutional republic. Since 2005, the Comprehensive Peace Agreement. Then they have a declaration of the Republic 2011, but they have never had elections. They keep postponing them. 15 years. They're even saying they'll have one this year, but are you a betting man, Mr. Arnold? Do you want to bet that they'll have the election? Or they will postpone it?
I think it
In
will be
South Sudan.
postponed.
I put my money with your lot as well. But anyway,
Yeah.
So I argued that, look, we're not unique. So where did we go wrong? I offered 4 of 5 from a strictly legal perspective. I said, look, we have to look at, one, who teaches law. Because the goal was to create a nation that is a nation of laws. All right? The essence of the constitution, the constitutional process, the essence of investing in a constitutional development was to, to remove these, to, to, to deal with these two problems. One, that the country rests on some sort of father figure. And then the gun. Let's just run the country on law and order. So, but that requires that we are entrusting the future of our republic to law schools. This is an unspoken reality. Are you with me, Mr. Katongole?
I'm with you.
Yes. So when you embark on constitutional development, it means, it goes without saying that you are entrusting the vitality of your republic initially to law schools, because law schools are the nursery bed of lawyers who are going to move forward into the rest of the levels if it can be a step change. So so we have to make a critique of law school. What went wrong? Things went wrong in the law school. And for a long time we had one law school. You hear me, Mr. Katongole?
Yes, I
That's
hear you.
Makerere University. So we would have to have a critique of the law school. And the critique of the law school exists. Actually, the critique of Makerere University as a law school exists. And I will return to it later. But let's pack that. After the law school, we then have to look at, because that's how law is taught. Then when lawyers graduate, they join the bar. So we have to look at this fraternity, this community of practicing lawyers. How have they been traditionally organized? What have been their ideological underpinnings? How do they view their role vis-a-vis this attempt at statehood? Do they see themselves as anchor statesmen? Are they statesmen lawyers, or they are they are hunter-gatherer lawyers? Are you with me?
Yes, I'm with you.
Yes. So that critique also you put in the box. We shall return to it later. Then you also look at judges, because now we're looking at how the law is interpreted. Who interprets the law? But I think I have gone ahead. We have to look at who writes the law, who makes the law, and that's Parliament. Those are local councils. Those are politicians. How do they take themselves? What is the legislative tradition, culture, and performance? How did legislators take themselves? How was the same concept you're asking? What has been the nature of wear and tear? Has legislative culture been progressive, or it has been in decay? Are you with me?
Yes, I'm with you, counsel.
Yeah. So because there's no way legislative, you see, decay is contagious. So if there's decay within the institution of parliament, within lawmaking, if the laws themselves that come out of parliament is like tanur. You know tanur? What's tanur in English? The furnace that makes the brick, right?
Yes, a furnace of the bricks. Brick furnace.
Yes. So if if the furnace is improper, the bricks are going to come out, of poor integrity. And that means the structure, the houses we are going to build with these bricks are going to be inferior. So so there's a critique of the legislature. For instance, is our parliament aware of the laws? Remember, we inherited laws. We operated since independence. We operated on what we call received law. So we were given what I call fake law by the colonists, because the colonists exported their law, imposed it on us for the purpose of serving colonialism. And then we inherited it, and when we got independence, we didn't embark on dismantling colonial law and colonial, the whole institution of colonial law. So, which parliament has parliament been aware of this historical burden, or it has just sharpened the rigors of colonialism in lawmaking? That has an impact on where we are. Then that we can make with when laws are made, then they have to be enforced. So who is enforcing law? What is the structure? I think last time we discussed, and I told you how during Kaihura's time, Kaihura was appointed IGP in 2000 and what was it, 5? 2005, right?
Yeah, after General
November 2005. I remember his first day at work. We had a strike at Makerere, and he turned up. Very excited. So he was appointed to be an IGP of the Uganda Police Force, an institution that, according to this constitution, was created in 1995. Are you with me?
We are together, Counsel.
So during at some point in his tenure, I think around the year 2012 or thereabouts, the police celebrated 100 years. Do you remember? Arnold, you were around then. You were practicing.
It's okay.
Yep. Yes.
Did you remember the police celebrating 100 years?
But the celebration was not that. It didn't look 100 years. I mean,
no, they did. They were celebrating 100 years. They gave history.
Yes,
in fact,
yes, I'm saying, but
on their website,
the nature of the occasion and the time they were celebrating, the two were distant of one another.
Okay, you can refine it this way.
Yeah.
That it came as a shock to those of us who are devoted to the constitutional project, to see the people in charge of enforcing Uganda law. Are you getting me? Celebrating a ghost institution that we don't know. Because the Uganda Police Force we know, by 2012, are you with me? Hold on, let me do it to my.
Okay. Okay, Counsel, as Counsel takes a break, there are several issues he's trying to raise and do a comparative analysis and take us back in the history and show us where did we lose or where did we get to the point where we are and decry.
So, yeah, I was sharing that
the police celebration of 100 years of 2014, yes.
Yes. So the Uganda Police Force should have been celebrating, give and take 17 years. Okay? Because it was established in 1995. Are you with me? So in 2000 it had 5 years, and in 2012 it would have had 17 years. But this institution was celebrating 100 years. So Kaihura and everybody in the police were seeing themselves as members of the Askari force. The Askari force that had been brought into Uganda by Captain Lugard. The genocidaires. Okay?
Yep.
Are you with Mr. Katongole?
Yes, I'm with you.
They were celebrating themselves as part of a genocidal legacy. The legacy of a genocidal force. Okay? That had been raised by colonial power to capture, dismantle, subjugate the people of the Great Lakes region. Look at this army, plain and simple. They were tying themselves very intimately to that legacy, very proudly. They even put it on their website, and I think it is still there. If you go to their website on the Uganda Police Force, they proudly say, "We are the successors of the Askari force." Now, that helps you understand how did things get this bad. How did we get there? I'll give my summation, but I hope you gather. Now, the police is not the only institution enforcing law. We have the security forces, which have never recognized that law enforcement is a constitutional function of the police. So, you have the UPDF, which constantly argues that it was in charge of law enforcement as the NRA. And it continues to maintain, military police. It continues to see the Uganda police force as a body that has never achieved true independence. I think we recently saw a highly publicized law enforcement function at the home of the former speaker, right? You were there, Mr. Katongole. Are you with me?
I'm with you, counsel.
Yes. What was the army doing at each of those venues? Because you saw it, right?
Yes, I did.
And the law enforcement action was the responsibility for it, the spokesman role for it was being channeled through the head of the military institution, right? So that helps you understand, put into context, how law is enforced in Uganda. I will speak briefly to the issue that affects very many Ugandans, the intelligence services. Under our law, they're recognized in the constitution, and I think we have two acts that I'm aware of: the Internal Security Act and the Crime Security Act, which establishes ISO and ESO, respectively. Then, but I'm not so sure about the military intelligence institutions. But I think under the recent APDF Act, they made it far more clear now. And they call it the UPDF military establishment. They acknowledge that even the military intelligence services must be a creature of law. And so they try to give them recognition, and they try to make public, for the first time in a long time, they make public these organs. But very many Ugandans have reported consistently that they have been abducted by security forces that are not the police. And when their relatives, lawyers look for them at the police stations, the police says, we don't have them. So who has them? And so when lawyers draft habeas corpus applications, they tend to include intelligence organizations. They used to call them CMI, ISO, and so on and so forth. But what is the role of those functions? Even in law school, they don't teach you. Even in practice, there's very limited jurisprudence that clarifies their roles. And so the public is left with this big confusion about their role in law enforcement. But we shall discuss them later in detail. So then that brings us at the apex of the whole situation. Who is interpreting law and how are they interpreting the law? The truth of the matter is that there has been decay, and I think decay in the judicial institutions is the most visible because the judiciary, in the entire ecosystem of law teaching, law making, law enforcement, law interpretation, the most accessible to the public has been law interpretation. People can access the courts and observe the judges at work most of the time. And I think the government surveys also, the existing surveys, Transparency International, IGG, Afrobarometer, NEPAD, so many surveys. When they survey people's attitudes about law, people speak most especially about the judiciary. Because it's the most accessible. Most people can't access law school, Mr. Katongole. All right? We now have up to 20 law schools now, but it wasn't always like that. But there's a huge cost. The cost of accessing law school at a minimum is about 10 million a year. The cost of accessing an ordinary court is not 10 million, although it is still prohibitive. Ugandans report. So people's opinions about the whole decay and decadence of law tends to be reflective of their perceptions of the justice process as practiced in the courts of law. So most Ugandans can't really survey the quality of legal education, the quality of parliament. They just keep voting, parliamentarians, and they are voting them for, I think now things have changed. Now they vote them for buying an ambulance, political party affiliations. They have been denied civic education, so they don't really have the tools to judge parliament, and so on and so forth. And also parliament is not compulsory. There's no obligation to vote. It's not coercive. But court is not avoidable. If the police have arrested you and your mother or your relative, you're going to have to deal with this institution. So most people have opinions about this. I can call it the end of in our time in council, we have called it the police to prison pipeline. So most Ugandans' view of the law and how it has decayed is summarized in the police to prison pipeline. They have a fair view of what life is at a police station, before a magistrate, a judge, and the prison system. And there's a danger of focusing the conversation there. And that means silently or involuntarily, unwittingly excusing all the other actors in the ecosystem. So, having given you that context, how did we arrive here? In short, one, through hope. We had great hopes that enabled the making of the 1995 Constitution. So because of the great hope, and I'm speaking with hindsight, I wasn't there. Maybe now even me, if I was there, I would have had the same hope. I can see it with my parents and our neighbors and our friends. They had this massive hope of we can actually make it as a country. So there are certain, I can call it guardrails we didn't put in this constitution that we should have put in this constitution, and I'm sure we shall put it in the next constitution, because I think everybody is convinced that this constitution has reached its use by date. It's now very clear the purpose of this constitution. It was engineered and rigged to support a life presidency and a military dictatorship disguised as a democracy, as a constitutional democracy. The whole facade, the mask has fallen, and this reality is known. Now people don't have that hope. They have to deal with a very crude reality. They have to divide themselves into conformists and what I can call reformists, and at the extreme end of that, the resistance. Now, me, of course, I fall within the non-conformists, and within the non-conformist camp, of course, as I've told you, we don't agree. There's so much disagreement there. And there's also confusion, to be honest. So we really haven't designed a vision and a program of action to conduct a perfect resistance against what is now known by everybody. I am one of the optimists. That's why I keep hope. But others have lost hope. So many people, and I'm speaking, when I say people here, I mean people in the legal ecosystem. They are hopeless. They have given up hope. And so they have chosen to find comfort in conforming, or making do with piecemeal reforms, that can permit them to take a living out of this neoliberal disaster that we are. But ultimately, as Ugandans say, you are always one hospital bill away from abject poverty.